Social justice means applying the law equally to all people. But in practice, that doesn't always happen. I'm John Gonzalez. I'm here with my law partner, Jack DeRora. We practice law. We seek social justice. On this show, we reveal the conflict between the two.
You know, for a while, it was just us in the office over a cup of coffee talking about the news of the day. With social justice issues dominating our culture, our focus became how do we, as lawyers, make a difference?
And now it's not just us. Today we have Mark Brown, constitutional law expert and professor at Capital University Law School. Mark's a favorite of our program. Welcome back, Mark.
It's a pleasure to be back. Thank you.
We're going to talk about the United States Supreme Court. Haven't heard much from them lately, have you?
No, they've been hiding.
I was reading somewhere that the Trump administration has sought emergency intervention 28 times with the Supreme Court just this term, his first year. And when you think about it, first of all, that's more than Biden, Bush, and Obama combined.
I'll bet.
And the court only hears, what, Mark, 60, 70 cases a year?
Exactly, yes.
So this emergency docket is, according to the article, really taking over the court's time.
Sure it is.
And one of the problems that the author was saying is that the lower courts are having a hard time interpreting these emergency rulings because sometimes they don't even write why they're deciding it. And one appellate panel wrote, "We can only guess as to the court's rationale when it's not provided."
Yeah, what else?
It's a strange way to run the court system. Would you agree?
Oh, I firmly agree with you on that one. And a lot of people do. A lot of the constitutional community is concerned with the shadow docket, we've called it.
Yeah, and so, first of all, why does the court have a shadow docket or an emergency docket? What is the role of the Supreme Court in these cases?
It's always been there. Historically, it was primarily limited to death appeals, death row inmates trying to block executions. For quite a while, the Supreme Court even had a death clerk who fielded the death row inmates' applications. But it wasn't used for much more than that. Every now and then a case would come up on an emergency application. It's only recently, primarily with the Trump administration, even though the Biden administration used it a couple times, and so did Obama. But the Trump administration has really made use of this emergency docket, basically trying to block lower court decisions by applications to the Supreme Court. Stays, that's what they want, a stay.
So these are cases that are in the middle of being decided by the lower courts, but there's been some type of an injunction, and then the Supreme Court is weighing in on whether to keep the status quo or not.
Exactly.
I take it. All right. And who's winning these?
As predicted, Trump is not in the lower courts. I think we all agree that most of what Trump has done by executive order is illegal or unconstitutional. So the lower courts, predictably following the law, have ruled uniformly against Trump in a whole lot of matters. But as those matters then percolate up to the U.S. Supreme Court on the emergency docket, the shadow docket, the U.S. Supreme Court has it's a fairly large percentage of the time ruled in favor of Trump, blocking the lower court orders.
Well, hold on for a second. Let's be clear. He's just denying the Supreme Court is just denying the injunctive relief. It's not really ruling on the merits. Am I correct?
Well, that's the argument. It's not a decision on the merits. It's just a stay to keep matters where they are. But the reality is these decisions are having precedential effect, and they are changing the status quo.
Okay, thanks.
Plus, if the standard is like it is in our state courts, to get an injunction, you have to show a likelihood of success on the merits. So I assume the Supreme Court's saying the Trump administration has the likely success. So that's sometimes a scary proposition. The one I'm thinking of, Mark, is the birthright citizenship. What had happened, and correct me if I'm wrong, but a couple of these lower courts did nationwide injunctions to prevent the Trump administration from its
executive order.
Yeah, on birthright citizenship. Is that correct?
That's exactly right. Yes.
And then what did the Supreme Court do with that?
The Supreme Court took it up at Trump's request. Interestingly, Biden had made the same kind of request a couple of years ago when he was in office, but the Supreme Court rejected that one. It didn't take that one up. But it took Trump's, and it
Wait a minute, on the same subject?
No, not on birthright citizenship,
Okay.
on the availability of nationwide injunctions.
Oh, okay. Thank you.
And I'm sorry, I didn't mean to confuse that. But the U.S. Supreme Court ruled, as we expected, that nationwide injunctions are generally impermissible. District courts don't have that power anymore. So in order to get that kind of relief, the court says you really need a class action. Or there's another exception for matters that need nationwide injunctions for complete relief, which is pretty tricky and pretty rare. But it's basically class actions now going forward.
And some of the lower courts, especially in these birthright citizenship cases, have decided to make them class actions, right?
Exactly. One court out of New Hampshire did it right out of the gate. Said, okay, it's a class action, granted.
Are other courts pushing back on some of the Supreme Court's rulings in that way?
I wouldn't say they're pushing back as much as they're just trying to follow the law. And then when the Supreme Court issues these stays without opinion, you've got to guess at what the law is anymore. And interestingly, I know that, and this made news, Justice Gorsuch and Kavanaugh, in an opinion, one of their shadow docket opinions, complained about that and called out like 3 federal district judges and said, hey, you guys need to follow our opinions. And we con law people are looking at each other and going, what opinion? You didn't write anything. So and it's really making it difficult for the district court judges to operate because the Supreme Court is changing the law by shadow docket without opinion. So it's who knows?
Again, not knowing the inner workings, especially of this court, one of the articles I was reading, Mark, said that the shadow docket, you really don't know what's going to come out of it because they can rule in Trump's favor to stop the nationwide injunctions. But they may not have a majority of the court to actually rule on the merits at that time. Is that the way you kind of understand the limitations of what's going on?
Oh, certainly, and that's historically been true. I mean, you need 5 votes to obtain a stay, just like you need 5 votes to win the case. You only need 4 votes to get the case up to the Supreme Court, so there is a difference there. But, historically, we've recognized that maybe a stay is not the ultimate conclusion of the case, but I think we've come to realize now that with the current Supreme Court, it probably is.
They're definitely projecting, and I've been reading a lot of negative articles, commentary on Chief Justice Roberts. But the gist of them is that, he came from, Reagan? He was in Reagan's administration.
As did Alito, if I'm not mistaken.
Yes, I think you're right, Jack.
Yeah, and he clerked for who, Rehnquist, maybe?
I think that's right.
Yes.
And so he's got this idea of a very strong executive, and he seems to be motivated by giving the president as much power as he can, which, to me, being an attorney and being in the judicial part of government, I just don't see how judges can give up power. Is that happening?
Oh, yes, and you're exactly right about Roberts. He's really a fan of the so-called unitary executive theory. It's really a creation of the Federalist Society, which Roberts is part of. And it's been on their agenda for quite a while, along with gun rights. That's another one. And they've been very successful. So they're pushing this unitary executive theory, which basically overrules 100 years of Supreme Court precedent by giving to the President of the United States almost unlimited power over the executive branch. It's happening. And we can talk about some of the cases that are on the shadow docket right now that have already pretty much implemented it. But yeah, Roberts is a big fan of that, and so is the Supreme Court right now.
And there's no pushback from Congress. I was telling Jack, we were talking about, I saw a senator say that as far as he's concerned, he's voting for anybody that Trump puts up for any office because Trump gets the people that he wants in. That's his position. And I thought, well, maybe he should follow the Constitution and give advice and consent instead of just letting Trump do what he wants. But the legislative branch has also decided that it's not going to push back.
Not at all, and that's concerning. And Justice Robert Jackson talked about that particular problem in a case called the Youngstown Sheet and Tube case. During the Korean War, Truman tried to seize the steel mills. He did, in fact. He lost, but Robert Jackson wrote a famous concurring opinion against Truman. And he mentioned that. He said, well, sometimes Congress is going to acquiesce and not take its part seriously. And he said, but that doesn't mean we shouldn't. So we, the Supreme Court, need to step in and still do our job just because Congress isn't doing its job. And I think I wish it were true today.
It doesn't seem like it in the cases that are before the court. I got to imagine it's these appropriation cases where Congress has appropriated the money, but the Trump administration just doesn't seem to care. And both, I know there's foreign aid, there's the money that's going for grants for research. Are those the cases you're talking about?
Those are a couple of them, yes. And it's pretty clear, in my professional opinion, it's pretty clearly illegal what Trump is doing. Congress has even passed a law to deal with the problem because Nixon tried that way back when. So Trump does not have the authority to withhold that spending, in my professional opinion. But the Supreme Court's not doing anything about it. Instead, it has stayed district court orders to let Trump do it. And that's the status quo.
I think what this conversation shows is how important it is to really grasp and appreciate the predilections of candidates for judicial office before they take their place on the bench. It's not as if John Roberts came to the Supreme Court and said, wow, this unitary theory makes a lot of sense to me. No, he was a believer, or at least in the nascent stages of believing as a lawyer. And I suspect if we looked at Kavanaugh or Gorsuch, we'd find the same. So what it means is we shouldn't be surprised at what we get, and like-minded people appoint like-minded people. It's pretty simple, notwithstanding this notion we have of great justice and equality in D.C. Or am I missing something?
No, you're exactly right, Jack. We knew this was coming from the appointments. The Federalist Society, like I said, this has been a big thing on their agenda, and all of the justices appointed by Republican presidents since Roberts have been members of the Federalist Society, so we knew this was coming. One of the shocking things, I think, is to most of us is the way it's come. We really didn't expect it to come on the shadow docket, which is where it's come. You expect these things to be fully argued, briefed, thought out, and that's not happened. Instead, it's been a phone-in where the Supreme Court, that's what we used to call it, when you're just phoning in instead of briefing. And the Supreme Court is making these marked decisions.
Well, when we look at Roberts, now, has he just done his 20th year on the bench? Is it
about 20, yes.
Yeah, there's an anniversary, I thought. But if I recall, he was one of the last justices that got a lot of support in the Senate. The more recent ones it was almost a 50-50 on the confirmations. But, I don't know if anybody could have predicted what the Chief Justice is doing just from his confirmation hearings. Maybe. But, he got a lot of support, if I recall. Do you know?
No, he did. I don't remember exactly the vote, but you're right, it wasn't close.
Well, isn't that, I can't go back historically to that hearing process before the Senate, but it makes me wonder if anybody was really looking at what he was writing during his years in the Reagan administration. And in fact, when Alito gets criticized for the Dobbs decision, if I'm not mistaken, I think I read that he was an advocate of eliminating abortion rights years back when he was a government attorney. So why are we surprised? We're just not digging, or we don't care.
The constitutional community cares, I will say that, and it's not been a surprise to us with either Roberts or Alito's action. I mean, we knew what we were getting with both of them. We really did. And,
well, you being a very small sector of society.
Yes.
No, I'm being serious. I'm
Sure.
not trying to be a wise guy, but...
Well, but Roberts used, and I'm not saying this is not a legitimate argument, but Robert was saying, look, I was a government lawyer. I was doing my job making these arguments on behalf of my client, which you and I do every day. We may personally not think this is the right course, but we argue on behalf of our clients. That's what Roberts was saying during his confirmation. Hey, this was on behalf of a client. Now I'm going to be...
Well, I don't...
You know, the umpire.
I understand that argument, but I think when you are making arguments of that magnitude, you got to believe in them.
Well, yeah, maybe. But, I sued the Girl Scouts once. I hate to say so.
What?
Oh, yeah.
Hold on. Stop everything right now.
Bad cookies. Now, but talking about appointments, and especially Trump's appointments, there's this judge in Oregon that just stopped the National Guard from being deployed there, and she was a Trump appointee.
Right.
What's the constitutional basis for either preventing that or what Trump's trying to do with sending the National Guard to these cities?
Well, the president, under the Constitution and under federal statutes, can call the militia, which we now recognize, we call the National Guard today, into federal service. He can do that. He has the power to do that. Or ordinarily, the governors have the authority over the militia, but the president can call them into national service if certain emergencies arise. Most often, he needs the consent of the governor, but there are workarounds for that too. And the Insurrection Act is one of those workarounds. If the president makes a finding that there is a rebellion or insurrection, he can call the National Guard up into federal service and use it. So he does have that authority constitutionally and as a matter of statutory authority. And that has been used by past presidents. Eisenhower used it with Little Rock back in 1957 during the desegregation crisis. Kennedy used it with Alabama, George Wallace, and Mississippi with the governors there resisting integration. And Johnson used it with Selma, Alabama. Alabama. Mm-hmm. So it has happened.
So what's the justification then for this federal judge? And I think there's maybe been two others that have denied the deployment, saying that he doesn't have that authority.
Basically, the judge said, I don't believe you. She says, I live here. There's no insurrection in Portland.
Well, now, isn't that sort of a breach from protocol? Because typically, doesn't the judiciary just defer to what the president says regarding matters of emergency? Or have I been reading too much into...
No, you're right. Usually, the courts will defer to the executive's good faith determinations. Mm-hmm. And, you go back to Eisenhower and Kennedy and Johnson, and those decisions were made in good faith and with a lot of deliberation. And then there's Donald Trump. And I think what we're seeing is the courts, like the rest of us, our jaws are dropping, and we're saying, we don't believe you.
So the posture of these National Guard cases, if we can generally refer to them that, is that the courts are issuing injunctions against the president for deploying the Guard to these states.
Yes.
So likely an emergency shadow docket case for the Supreme Court?
Oh, certainly.
And so, Mark, what's going to happen?
Oh, the Supreme Court's going to stay the injunction. I have no doubt about that. In Portland, yes. And in California, we saw the same thing, but the Ninth Circuit stayed the injunction. It didn't even have to go to the Supreme Court. So, yeah, that Portland judge, I think she's right, but she's going to lose.
She's going to lose the injunction, but again, that doesn't necessarily mean they lose the case.
Yeah, technically, effectively, though, it does. because it'll be over once, you get to the final judgment. The troops would have been used, hopefully gone home, and that will be the end of it.
Oregon is in the 9th District, right?
9th Circuit, yes.
Or, excuse me, 9th Circuit. So I don't mean to be taxing your memory, but how did the 9th Circuit overrule what that district judge did for Los Angeles?
It stayed the district court order.
That's what I mean. It stayed the order. What was the logic behind that?
I think correctly, actually, it stayed the order because there was it was a technical case. Governor Newsom refused to consent, and then Trump went over his head, and the question was whether the proper procedures were followed. And so it was kind of a technical problem. And the district courts enjoined the use of the National Guard, but the 9th Circuit stepped in and stayed that. And like I said, I think the 9th Circuit was probably right on that one. And so it never had to go any farther. The Oregon case is a much cleaner question of just whether Trump can, whenever he wants, declare an emergency and send in the troops. That wasn't necessarily so in Los Angeles.
Thank you.
I liked what Newsom did too. And I don't know how far this has gotten, but wasn't there now a law in California that they cannot cover their faces? And I don't know if he has the authority to do that to federalized, I don't know what we're going to call them, troops or law enforcement. Does he have a basis to pass such a law?
I think he's got a basis, but I think he's going to lose. I think the federal ability to wear masks is going to preempt any state law to the contrary. It's kind of like the post office. You can't make the postal trucks have state license plates. The federal law preempts that.
It just seems un-American to have troops in our cities. But what you're telling me is that if the president in good faith thinks that they should be, there's a constitutional basis for it, which I guess makes it an American thing.
Yes. In fact, if you want to go all the way back to George Washington, he invoked the old variant of the Insurrection Act. I don't know if you remember, Gonzo, the Whiskey Rebellion.
No, I don't, but I think Jack was there. What happened, Jack?
I don't know. I had too many shots to remember what was going on. I heard it was a big deal.
What was the whiskey rebellion?
Oh, in Pennsylvania, Hamilton wanted to impose a tax. He was trying to force more currency into the American economy. So he taxed whiskey. And of course, the producers of whiskey didn't like that. So there was literally a rebellion. And George Washington called out the militia, federalized them, sent in the troops, and squashed it. So thinking about troops on American soil, what is also going on is that Trump seems to be starting a war with Venezuela, or at least with their fishing boats. What's the constitutional basis for that? It doesn't seem like Congress is on board with it. Yeah, that's that's crazy, the stuff that's happening on international waters. The Constitution of the United States, however, doesn't apply to international waters. It applies to U.S. citizens on international waters, but for foreign nationals, the U.S. Constitution doesn't offer them any protection at all. So as far as the Constitution goes, there's nothing really that Trump is violating. Of course, he is violating the heck out of international law, but that's a different question.
Mm-hmm.
I have a question about Congress's role. We hear so often in the news, in fact, I think you said it, that Congress is ceding its power to the executive branch. Okay, I get that. I'd like to have a couple examples, if you can do it, where Trump is exercising more authority than he should, and what Congress, on a practical level, could do to say enough.
Well, take the Trump administration's decision to threaten schools, universities, law firms with a forfeiture of their federal grant money, unless they do X, Y, and Z.
Good example. Okay.
I think I've read most of those pleadings, and I think Trump's way out of line there.
Sure.
Clearly violating federal law. Now, how do we rein him in? Congress can pass a statute, and the statute can make it clear to Trump that he no longer, well, he never had that authority in the first place, but he no longer has that authority. So that's one thing Congress can do.
So it's passing legislation that goes to Trump's desk anyway,
which he's going to veto.
So then we'd have to have a 2/3 majority
to override. Yes.
To override.
So the other option is you impeach him and you remove him from office, right? Well, we've been down that path a couple times, and the closest we got was 57 votes.
So forgive me, Gunzo, let me finish this up real quickly. So, all right, so the statutory process is a dead loser. Have traditionally presidents listened to just members of Congress arguing, haranguing the president for overstepping, or do presidents just generally say, get out of my way?
They usually try to cooperate somewhat, yes, and Trump's obviously the counterexample.
Okay.
Today.
So jawboning did have some importance in years past when it came to trying to rein in a president.
Oh, sure. Even, with Clinton. Clinton did that very effectively. Johnson, of course, was the master of the Senate, so he did that a lot. Kennedy was very good at that. FDR was probably the...
Well, I said jawboning, which is attributed to Kennedy, but I meant, has it been effective traditionally for Congress to jawbone the president into acting consistently with his executive power?
Yes, I think so. Coupled with the filibuster in the Senate, too, yes.
Okay.
Yes.
I think it'll be interesting to see if the next president is a Democrat, if there will be laws passed like this, unless the Democrats just think, hey, Trump got all this power, now we're going to use it to reverse or even go further. I'm kind of curious. My hope is that if there is a Democrat in the Oval Office next time, that Congress will rein in and take back some of this power.
Yeah, that's my hope too. I mean, to the next step, though, the problem is even if Congress does that, passes a law, if you have another president like Trump, he's just going to ignore it. So until the courts are willing to step up, and that includes the Supreme Court, effectively, even laws are not going to rein in a rogue president.
A lot of pundits are predicting that the House is going to go to the Democrats, but I don't know if they're saying that about the Senate. But let's assume for a minute both are Democrat. I think there's a good likelihood there will be an impeachment. Now, if I recall, the Supreme Court gave Trump immunity, but it was based upon the fact that he could always be impeached. Or does that immunity have some effect on Congress's ability to impeach him?
No, it's not supposed to. But, who knows what the Supreme Court might do next. That immunity decision all by itself was pretty shocking.
That's one of my favorite subjects. So can you explain how the Supreme Court arrived at that immunity decision, and explain first how it clings to this notion of textualism, and compare those two thoughts?
Well, I can do it in reverse order. The textualism doesn't exist. There's nothing in the text of the Constitution that grants the president that kind of immunity or any immunity at all. Now there is for members of the House and Senate. There is something in the Constitution that does grant them immunity, nothing for the president. So it's been made up out of whole cloth. Now, going to your first question, I can't explain what the Supreme Court did. It's contrary to everything I've been teaching for 40 years. We understood for 40 years that even though the president could not be criminally charged while in office, he could be criminally charged after he left office. That was the assumption behind Gerald Ford's pardon of Richard Nixon. And the Supreme Court just changed that. The Supreme Court said, nope, no criminal prosecution ever for the president.
It's very, very broad, but you wonder what the people working for the president are thinking because they don't have that immunity. It doesn't extend down, but I could see Trump doing a blanket pardon when he leaves office of everybody.
Sure.
And there'll be no accountability. I heard a congressman saying if they take back Congress, they're going to start investigating these lawyers in the DOJ and see if they are violating the ethical standards and things like that, which will be interesting because that'll happen during Trump's administration. But, I could see Trump just pardoning people. So,
Let's go back for a second to Trump's expansion of presidential power. When we look at how the Supreme Court generally operates, it's the matter of precedent. How have we decided in the past, unless there's a significant problem, we're going to try to decide this case in a manner that's consistent with prior cases. But yet when it comes to Trump's expansion of his powers under Article 2, the court never, at least I don't think the court is saying, well, let's see we don't have a whole lot of information here, at least I don't think there is, but in fact, what I just said is incorrect about not enough information. But the court, I don't think, ever says, well, let's go back historically and see what powers the president has used and if there's a historical basis for this. And I would think that there's not a historical basis for much of what Trump does. And if I'm right about that, why isn't a historical analysis appropriate? That was a mouthful, I'm sorry.
I think history has always played a large part in constitutional adjudication, no doubt about that. And then each successive court builds on that use of history. And we assume the justices are pretty savvy, pretty smart people, so we tend to respect their conclusions. But, of course, the court has always, at some point, felt free to overturn itself and start decisis to the wind. We're going to change things. So it's a tension. There is a tension there. Specifically, if you go back to the founding, there's simply no way you can justify the amount of power that Donald Trump purports to exercise today. There's just no way historically you can do that. The framers of the Constitution felt very, very strongly about prohibiting the development of a monarchy. They were very, very strongly in favor of a Republican form of government, representative government. George Washington was well respected, but also well limited in what he could do at the founding. So historically, there's just no comparison to what is happening today. Why the court has ignored that history and gone off on this unitary executive theory, I don't see any rational explanation, not historical rational explanation for it.
When we go back to this immunity decision, one of the things that came out of it was the broad language about Trump's role with his DOJ and Attorney General. Summarizing the decision, basically Trump can control his Attorney General and what the DOJ does, which brings me to Comey. What do you think about the prosecution of Comey and Trump's role in it? Is that going to help James Comey's defense, or is it going to be a non-factor because of the Supreme Court's decision?
Now that I'm not sure about, Gons. I think I better pass on that one. I haven't really thought that much about Comey's defense, so I'm not sure.
One of the things that, a couple of things that have come out that I think are very interesting, so I'm watching it, is one, who was married to Trump's aide?
Newsom.
No, Kelly Conway.
George Conway.
George Conway had a very interesting take. He said that because this lawyer that Trump appointed to do the indictment signed the indictment before she was formally put in place, it's an invalid indictment and the statute of limitations is run. I haven't heard anybody else comment on that, but I thought that was kind of interesting. But more so, it's the idea of vindictive prosecution. And certainly some of the least people that I'm reading say that if it's very tough to defend a federal criminal indictment on vindictive prosecution. But if there is ever a case, this might be it.
It is hard. I can say that. But there, like you said, you can win on that theory. Daniel Ellsberg, remember Daniel Ellsberg?
Sure.
Yes. When
not many people listening to this podcast would remember that, but we do.
The charges against him were ultimately dropped because of Nixon's prosecution's vindictiveness, yes.
Yeah, and it seems to be pretty clear that Trump's going after his political opponents. I think Jack and I may agree if somebody did do something that was against the law, they ought to be held accountable. We think that for the Trump people. We've got to think it for the Biden people and everybody else. But let's talk about the tariffs for a minute. So the Supreme Court's going to actually rule on the merits of Trump's tariffs. And what the administration is saying is look, we're bringing in billions of dollars. How are we ever going to repay that if the court tells me I didn't have the authority? What's your thought on the merits of the tariff power that Trump's exercising?
Well, in a perfect world, Trump should lose the case, because he does not have the authority. I mean, there are lots of grants of power under tariff statutes to the president, but most of them have procedural requirements and limitations, caps on tariffs, for example, and Trump doesn't want to use those. So he picks a statute that doesn't say anything about tariffs and then uses that to impose these outrageous tariffs on American citizens. Trump acts as if it's being paid by foreign governments, which is not true. You, me, and Gonzo were paying those taxes. So if you look at the statute and you look at the precedents, I just don't think there's any way Trump could win that argument.
But
with that said, you've got a Supreme Court that's very Trump-friendly, and there's no other descriptive,
So that takes us to birthright citizenship. The court's going to rule on the merits of that at some point. What's your thought on whether Trump can limit birthright citizenship?
I think that he's going to lose that one, as he should. I just don't. I think he probably gets 3 votes. I just can't see Roberts or Barrett buying that argument. I just don't see that. I've been surprised before, so we'll see. But yeah, he should lose that one pretty. It should be 9-0. He may get a couple. He may get 2 or 3 votes.
A little off those subjects, the Supreme Court is going to consider the case involving the Colorado law banning conversion therapy treatment for minors. But my understanding is this is more of a free speech issue. What's your thought on how the court handles the conversion therapy?
Well, Colorado has banned conversion therapy. Colorado says, hey, they're professionals. We can limit the speech of lawyers. We can limit the speech of doctors. States have done that for years and years and years. But the Supreme Court, in a case a couple of years ago with professional speech, gave the professionals a whole lot more First Amendment protection. And I suspect they're going to build on that in this case to strike down the Colorado law. Also, the other factor, the wild card is religion, factors into that too. The argument is being made that, freedom of religion too. I've got this religious right to teach, convert or
to teach
to practice.
lunacy.
Yeah. So I think Colorado's going to lose that one. It shouldn't, but it will.
And then I think Hawaii has a gun case in front of the Supreme Court. Now, I'm not sure I know exactly what the issue is, but I think it's a pretty broad issue of a gentleman wanting to carry his gun onto private property like a retail outlet or something and being told he can't, which is pretty much the law in Ohio. If you put up a sign that says you can't bring a gun here, you're not supposed to bring a gun in.
The difference, I'm sorry, go ahead, John.
What do you think about the merits of that?
Oh, the difference in the Hawaii case is that the presumption is you cannot bring the gun on the premises. The premises do not have to post.
Okay.
They don't have to put a sign up. So Ohio's law is the opposite. In Ohio, if you want to keep the guns off, you've got to post it. You put a sign up. So it's just a matter of the presumption. And so what the Supreme Court's going to do, I think, is it's going to strike the Hawaii law down and say Hawaii has to do it like Ohio does it, so that the premises have to be posted. There has to be a sign.
I'm wondering, and I'm serious when I ask this question, if Las Vegas takes odds on these things. Because I'm serious, because you can go to Las Vegas, you can bet on anything. And I'm wondering if there's a Supreme Court betting line there.
Offshore. There are offshore betting services, yes.
Really?
No, are you serious?
Yeah.
And
But whoa,
you can bet on like the win-lose or how many, 6-4 or whatever, 6-3.
But so you can do it offshore. You can't do it in Las Vegas, you think?
I still think it's illegal in the United States, but offshore. I've been told.
Hey, I want to, we're running out of time, but I want to discuss something that you and I talked about ever so briefly before we started our conversation. And that is the book by Leah Littman, your counterpart at the University of Michigan. And the book is Lawless, How the Supreme Court Runs on Conservative Grievances. And basically the foundation of the book is, except for a very limited period of time, the Supreme Court has almost always backed the establishment. And she gives lots of examples. And I bring that up because I think the average citizen thinks, the Supreme Court, where wrongs are righted, right? And they sit and they look at things even-handedly. So respond to that sort of expectation that I think citizens have versus what Leah Littman is saying.
I've not read the book, but judging by your description, I agree with her. The Supreme Court has this image, my students especially, this image of the great protector, the great guardian of justice, doing good for the individual, taking care of minorities, et cetera, which is just not true, historically speaking. There's a short window of the Warren Court where the Warren Court, I think, did that. But that window closed in 1969. It only started in 53, 54, so it's a 15-year window. Yeah, other than that, you're exactly right. The Supreme Court has always been the great protector of ingrained property rights, establishment interests, the existing administration.
Well, Mark, let me see. Tariffs, court, in your mind, that Trump should lose that, or should lose it. Birthright citizenship will lose. Conversion therapy, they'll uphold free speech. Gun laws, they'll probably strike down Hawaii's. So we'd like to get you back here after the court is in play for a few months and see how you do on those, and what I'm sure is going to be a pretty interesting session for the Supreme Court. But we always appreciate your expertise and your thoughts in these matters. Thanks for coming.
Well, thanks for having me.
Oh, as always, it was a lot of fun. So thank you for coming. Hey, our thanks to WOSU and our sound engineer, Dalton Jones. If you like what you've heard today, tell a friend. We want this to be more than just us. We want it to be all of us. And you can help us by liking us or following us wherever you get your podcast. Submit a review. That would help. Help us elevate our profile so that other podcast listeners can find us. We'll be back in another week or so with another social justice issue. Until then, so long.